Welcome to my YouTube channel. Please like, comment, and subscribe. Extension of the LHWCA. To make sure that everyone in the maritime fields has the right to compensation for on-the-job injuries or illnesses, the LHWCA has been extended several times. For example, the Defense Base Act is an extension that provides coverage for workers hired by U.S. contractors to work in foreign countries or waters. The Outer Continental Shelf Land Act covers maritime workers in the private industry who work on the part of the Outer Continental Shelf that belongs to the U.S. Finally, the Non-Appropriated Funds Instrumentalities Act covers those civilians, employees working for social clubs, recreational facilities, and military post-exchange of the U.S. Armed Forces. And then next about statutes of limitation for the LHWCA. If you qualify as a worker under the LHWCA on the job, you do not have forever to make your claim and get the compensation you deserve. The statutes of limitations extend to 1 year beyond the time you discover your injury or were diagnosed with an illness. If your employer is currently paying directly for your medical bills and lost wages, your statutes of limitation begins when those payments stop. There are some other exceptions to this limitation. For instance, if your employer decides to stop paying benefits, you have up to 3 years to file an LHWCA claim. If your employer takes more than a year to file an injury report form, your statute of limitation is waived. If you only realize that your work environment contributes to an illness or injury years after the fact, your statute of limitation can be extended. This may happen if you have a repetitive motion injury that worsens over time, or if you become ill decades after exposed to asbestos on the job. And then next about LHWCA claim and appeals. If you are injured at work or believe that your workplace has made you sick, you can file a claim under the LHWCA. The most important thing to do first is to get a throughout accident report completed. You also need to get treated medically as soon as possible. If your employer, you, or anyone else involved disagrees with any part of the claim on or compensation, you will need this piece of evidence to ensure you get the benefits to which you are entitled. If there is a disagreement or conflict over benefits, your claim may go through an appeals process and a formal hearing with a judge. An appeal of the judge's ruling goes before the benefits review boards, and from there to a U.S. Circuit Court or even the Supreme Court. You should know and understand your right under the LHWCA if you are a maritime worker who qualifies. If you are injured or become sick because of your maritime job, you are entitled to compensation. Trust in an experienced lawyer, someone who knows maritime law, to help you through the process and to ensure you get all that you deserve. And then next about while seamen are protected by the Jonas Acts and given the right to sue employers who are negligent in the cause of an injury. There are other maritime workers who don't qualify as seamen. These men and women can be injured on the job due to an employer's negligence and may need protection under the law for compensation and the right to sue. This is where the longshore and harbor workers' compensations Act or LHWCA is important. It provides benefits and rights to maritime workers not qualifying as a seaman. These include harbor workers, longshoremen, and shipyard workers. The LHWCA provides protection for these workers in the event of an employment-related injury or illness. The federal law provides for compensation for medical bills, lost wages, and other expenses and is administered by the Office of Workers' Compensation Program. And then about provisions of the LHWCA. If you qualify under the LHWCA and are injured or become ill on the job, the law guarantees you certain compensation. Injured or sick workers are entitled to 66 and 2/3% of weekly wages for as long as the illness or injury prevent the worker from going back on the job. Workers also have a right to compensation for any injury that is permanent and to compensation for medical expenses. For workers that die on the job, beneficiaries are entitled to certain benefits under the LHWCA. This amount to 60% of the worker average wage for the surviving spouse, plus 16 and 2/3% of the average wage for each surviving child of the deceased. Funeral expenses of up to $3,000 may be provided as well. The employer is obligated to pay the expenses guaranteed by the LHWCA to injured workers who qualify under the law. Thank you for watching this video. Don't forget to give, like, comment, and subscribe